Let's try this again. It is July 27th, 2025, and this is part of a video journal of my recovery from the trauma of watching my little brother, Paul Kierans, 64, with Down syndrome, be locked up by the British Columbia New Democratic Party government with David Eby as a leader for 588 days, 172 missed visits. Paul was locked away after I complained to the Burnaby RCMP police about what I allege is a fraudulent and forged power of attorney that the government group home created to give my brother. They appointed my Catholic nun sister 4,000 kilometers away in Ontario, who's never been alone with Paul for a minute in her life, never cared for him. They appointed her as his guardian to give him the COVID-19 shot in February of 2021. And I didn't find out about it for a year, and I complained to the Burnaby RCMP in August of 2022. And within 4 days, the government group home terminated permanently my contact with Paul. After 63 years or 64 years of our visiting at will. So the good news is, and I hope this mic is working, I'm going to have to get a new mic. The good news is on July 24th, last week, Thursday, July 24th, 2025, I filed my application for leave to appeal to the Supreme Court of Canada. It's a tremendous amount of work. It was 164 pages long with a 20-page argument. The gist of my argument is that my Section 7 rights under the Canadian Charter of Rights and Freedoms, that is the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. They deprived me of my right to life by having, after Paul died, this cruelty and torture doesn't end there. They applied to have me declared a vexatious litigant for trying to visit my brother. And the judge that heard the hearing, even though the notice of application said that it was only for 30 minutes, they set it down for 5 days. And the judge heard it. On the second day, at 12 o'clock, I stood up and I said, I can't, I'm not allowed to stay for longer because I have a heart condition. And I've got a letter from my family doctor and from my cardiologist saying I couldn't, my court appearances had to be less than 2 hours per day. And the judge said, Judith E. Hoffman, remember that? She said, well, can't you just sit in the gallery like the audience? Can't you just sit in the audience? Well, my reputation and my life is being discussed in front of her. And I have letters from doctors saying that I have a potentially I had a heart attack in November of 2016, and I have a potentially life-threatening cardiac condition. I have high blood pressure, I have lupus, I've got kidney failure, and I am also a disabled person with a brain injury. I suffered a brain injury in 2008. But she said, can't you just sit in the gallery? And so I got up and I left quietly. And my argument at the Supreme Court of Canada is that my rights to security, the right not to be deprived of my right to life, liberty, and security of the person was breached by this judge going past my 2-hour limit, which is a reasonable accommodation would be just to have 2-hour court appearances per day. But no, she had to go for 2.5 hours, and then she doubled down. The next day she went for all day, from 10 a.m. to 4 p.m. for 2 days. And I said that it was not done in accordance with the principles of fundamental justice because she dismissed, I had an application before the court to visit Paul, and she dismissed that as being moot. She said she wasn't going to hear it because it was moot because Paul had died. But it wasn't moot to have me declared a vexatious litigant. So she went ahead with that. And also, on the day of the hearing, my sister's Ottawa, she had two law firms. The Catholic Church spent $1.5 million, and the Ottawa lawyer, who doesn't know anything about British Columbia and Vancouver practice or British Columbia practice, he filed a new notice of application that was 19 pages long the morning of the hearing. So I get served with a 19-page. The limit is 10 pages, which I know because I practiced law in British Columbia since 1991. He didn't know that. So he serves on me a new notice of application to have me declared a vexatious litigant. It's not in accordance with the notice because I'm supposed to be given at least 8 days notice, which I wasn't. And it was 19 pages long, and the page limit is 10 pages. And it contained all kinds of assertions that were false and defamatory, with little tab references to the materials that he filed with the court. He also, when you go to court in British Columbia in a chambers hearing, you have to file a binder of the evidence, your evidence and the other side's evidence, all together in a binder that has a table of contents before the judge. Well, he left out all my materials. So he left out all my responding materials. And when I stood up and I said, well, he left out my materials, my evidence, he said, well, she can print it off and she can file it if she wants. So we're right in the middle of the hearing, and he says I can print off my responding evidence and file it. So the hearing was not done. It deprived me of my right to life. It risked my life and was not done in accordance with the fundamental principles of justice. Like even the basic rules of court. It didn't comply with the basic rules of court. And that may sound complicated, but the gist of it was that this judge, somebody said to me, it's like she wanted you to have a heart attack. She was daring you. The judge, Judith E. Hoffman, was daring you to have a heart attack right in front of her. And that's what I felt. So I got up and I left quietly. And then in the court order that she signed after the hearing, where she designated me a vexatious litigant and took away my rights. So they locked Paul up and took away all his rights, and then he died. And then they wanted me to risk my life while they were taking away my rights. But in the court order that she signed, it said that I was there, even though I left. I left at noon on the second day. And then she went on for 2 more full days. But she said that I appeared. So it was misleading. Anyways, it's very exciting. We're going to win this one. There's, I believe, 800 applications for leave to appeal to the Supreme Court of Canada per year. Only 80 are out of that 800 are allowed to be heard, or might be even less than 80. But I believe without a doubt that this one is going to be heard. There was something sort of spiritual about writing it. I just felt like I was blessed by God while I was writing it. It just flowed. The words just flowed. And the reasoning just flowed. I mean, she risked my life. This judge. I mean, it's not very often you get a judge asking you to risk your life in court. I don't think it's ever happened before, and I hope it never happens again as a result of this. So I believe we're going to win this one. I feel quite confident. I got a very nice letter from the Supreme Court of Canada on Friday, very fast. Like the next morning, they wrote me back and they said they just needed to have, they assigned me a file number, which is 41902, and they said I need to provide them with affidavits of service that I've served this on the other side, on the nuns lawyers in Ottawa and Vancouver, and on the Attorney General of Canada and the Attorney General of British Columbia, which I've done. So I have to do those affidavits of service, and I have to there's some other sort of housekeeping things I need to do. But that's it. That's very exciting. And you're going to know somebody who won a big case at the Supreme Court of Canada. Take care, everybody. I love you all.